Good afternoon, everyone. My name is Hamza Trambu, and I am a solicitor and director at MTUK Solicitors, and I'm here today to talk to you about conveyancing. Conveyancing is about the selling, buying, leasing, and remortgaging of a property which can either be private or commercial in England and Wales. Conveyancing is one of the most high-risk areas of law in the United Kingdom of England and Wales. Team MTUK have been practicing conveyancing since the firm first opened, but the team involved has over 50 years' experience. The work we undertake requires meticulous care and attention, as the properties our clients are seeking to purchase or sell have an impact in their personal and/or professional lives. MTUK has always taken steps to stay up to date with the changes, with the thought in mind, how does this affect our client? When we are instructed, we begin on a stage-by-stage approach from start to complete of the conveyancing process. The first stage is known as compliance. We would start our matter when we first receive the sales memorandum or the heads of terms, which would identify the parties to the matter as well as who is our client and the property address. Once we have these details, we will then take further steps to identify our client in the form of obtaining their passport, driving license, a utility bill such as a council tax, as well as their last 3 to 6 months bank statements to identify their source of funding. Along with this, we would also have to establish if it's a purchase matter, whether they have a lender involved, and whether that lender is a lender that we are able to act for and on their panel. In the case of a sale or a remortgage, we would have to ask the client what is their reason for disposing of the property. Once we have all this initial information, we would have completed the first stage, known as our compliance. We now move on to stage 2, known as title investigation. Title investigation, when you're acting on the purchaser side, is that you receive the contract pack from the seller side. And when you're acting on the sales side, you are preparing the contract pack for the purchaser. On the purchaser side, you are going to investigate the title from the contract pack. Along with this, you would also order your property searches. The property searches you would order are known as a chancel check, landmark and enviro search, drainage and water, and local authority. By going through these documents, along with the title, you are compiling your inquiries that you are going to raise with the seller side. Along with that, you will also have instructions, if applicable, from the lender, who may have their own concerns that would also have to be raised. Now, when you're on the sales side, after the contract pack has been issued, you are just waiting until the inquiries have been raised by the purchaser. And once you have received these, you just need to get the information from your client and make sure that all the queries are satisfied. Next is stage 3, pre-exchange measures. After all the inquiries have been satisfied, from the purchaser side, you would then prepare for your client what's known as the report on title. This would be filled with your findings as well as your inquiries and responses from the seller side for the client to make an informed opinion on whether they want to proceed with the purchase of their property. If the client is satisfied, you would then take the next steps to check their anti-money laundering search and bankruptcy search to make sure that they are not in any way a PEP or have been declared bankrupt by the UK. If the results have also come back positive for your client, you would then now take the next steps, if it's applicable, to contact the lender. Make sure that you report to them and ensure that they are also satisfied to proceed. From the purchaser side, this is all that is required from the pre-exchange. On the sales side, you would just have to wait for the response from the purchaser side to confirm that they are ready to proceed. It would be just your job to ensure that the client is kept up to date on the progress. The same can apply for even the lease matters. In remortgaging, you would just have to make sure that all of your queries are satisfied for the lender. We now move on to stage 4, exchange of contracts. Before the parties can exchange contracts, the following requirements have to be met. From the purchaser side, they require the signed document, known as the contract, 10% of the purchase price. For example, if you're purchasing a property for $600,000, you would require 10%, which is $60,000. And you would need a draft building insurance policy. From exchange, the purchaser would be liable for any damage that happens to the property. So therefore, the policy is a must for their benefit. From the seller side, you just require the signed contract. The solicitors who act for the purchaser and seller, they would have to communicate with each other on the agreed exchange date, and once they have exchanged contracts, they would also have the completion date. After this has taken place, from the purchaser side, you would speak to your client and inform them to remit the rest of the completion funds onto your client account. If they have a lender, you would also contact their lender and request the funds to be remitted by or before the completion date. And on the sale side, you would be requesting a redemption statement if the property has a charge on it. Following exchange, the legal time clock starts ticking and both parties are bound by the contract. If for any reason the purchaser fails to complete, then they lose their 10% deposit, the $60,000 which I gave as an example earlier. And now we embark on stage 5, completion. From the purchaser side, you would be obtaining the funds from your client and the lender if involved. Once you're in receipt of all the completion funds, you would remit this to the seller solicitor's client account. You would then wait for the seller solicitors to give you a call to confirm receipt of the funds and to formally complete this matter. From the seller side, you would have the funds reaching your client account, and once they have been received, you would then pick up the phone and give a call to the purchaser solicitors and then complete this matter. From the seller solicitor's point, they would also have to contact their client to release the keys, and in case it's not their client, any nominated third parties, such as estate agents. However, if you're in a situation where you have not completed on the proposed date, the seller solicitors have the right to serve on the purchaser solicitors what is known as a notice to complete. This would force the purchaser to remit the 10% deposit immediately to the seller solicitors, and the seller would then have to wait 14 days after the completion date to complete this matter. 14 days is the amount of time that is available to the purchaser to rectify this fault. If the fault has not been rectified beyond the 14 days, the matter will then collapse. Largely speaking, these are the stages that are applicable in both private and commercial conveyancing. But this is not the end. There are post-completion steps to be taken on board. We now enter the hidden stage 6, post-completion steps. From the sales side, this would be just simply redeeming any charge that is on the property. However, from the purchaser side, the following steps have to be undertaken. The first is filing with HM Revenue and Customs the stamp duty land tax return. This would confirm that the purchasers have just bought a property. Same would have to be done even with the lease matter. After this, you would then submit an application to HM Land Registry, who keep all the records of all the properties in England and Wales. You would file with them the transfer form, updating the records to show the new owners who are the purchasers. This would also have to be conducted if there is any lease that is for more than 7 years. Once these applications have been submitted to the Land Registry, the solicitors would have to wait for the title deeds to return, and thus this would conclude the matter. This is what conveyancing means under English and Welsh laws. I thank you all for listening to me, and I also thank World Law Alliance for this opportunity to speak at this conference. If you have any questions, you can always speak to my team who are on the ground. Thank you.